back to Litigation Help. My name is Heather Hoyda-Twin. In this video, we're going to talk about the different family courts in Ontario. So joining me here today is family lawyer Helena Birt. Hi, Helena.
Hey, Heather, how are you? Happy New
I'm
Year and all the
great.
rest of that good stuff.
Yes, Happy New Year. So could you please explain to us what the different courts are in Ontario that hear family law cases?
Okay, I guess basically the place to start is you really have to pick and choose which court you actually should be going to, because there are a lot of different considerations that come into play, but then we'll talk about what all those are. So basically, in Ontario, there's 3 different courts that you can go to if you have a family law issue. Probably the simplest and easiest one, if you're lucky enough to have one of these in your jurisdictions, is called the Family Court Branch of the Superior Court of Justice. So just by its name, Superior Court means that it's a higher court. Doesn't really have a lot of significance for our people out there, except for the difference is if it's a Superior Court, the judges are appointed by the federal government. Okay, and then we'll talk about the difference with the provincial court later.
Okay.
So the Family Court Branch of the Superior Court of Justice is actually a specialized family law court. It's also sometimes called a unified family court. And it's the only court in Ontario that can hear all types of family law cases. It was created initially in a pilot project back in the late 70s and 80s to allow for basically one-stop shopping for in certain jurisdictions to hear all family law matters. There are currently 25 locations in Ontario that do or that have a unified family court. If you're lucky enough to be in one of these locations, you don't have to worry about what level of court you're supposed to go to. You just go to your local family court branch. So now you have to decide, if you're not in a place of a unified family court, whether you're going to go to the Superior Court of Justice. Depending on the issues in your case, that will be the determining factor about where you might have to go. Like, for example, the Superior Court of Justice is a higher court, has jurisdiction to hear divorce, division of family property, any claims relating to the family home. If you're in a common law relationship, if you might have a trust claim or a claim for unjust enrichment. So when you're making a property claim, when you're not in a married situation. The Superior Court of Justice will also hear applications and appeals relating to family arbitrations, parenting time, decision-making responsibility for children, child support, and spousal support. Judges are appointed by the federal government. And in the Superior Court, though, if you're not in a unified family court, your Superior Court judges aren't necessarily going to be just family law specialists. They are judges that will hear any cases that hear matters at the Superior Court of Justice level. That's not the case in every jurisdiction. Like in Toronto, for example, the Superior Court of Justice it's not a unified family court in Toronto. It's a Superior Court of Justice, and they actually have a specialized panel of Superior Court judges that hear family law matters. But it's because it's a big jurisdiction. In a lot of smaller counties and places across the province, a Superior Court judge will hear all kinds of matters, including criminal or civil litigation or anything else. So family law is just part of what they do. The Ontario Court of Justice is the provincial level of court. So again, it's considered a lower level. Doesn't mean that the judges are any less good than the ones in Superior Court. It just means that as a provincial court, the judges are appointed by the provincial government, not the federal government, as they are with the Superior Court. So when you're in the Ontario Court of Justice, it can hear family cases involving parenting time and decision-making responsibility for children, child support, spousal support, adoption, child protection, and enforcement of child or spousal support, whether it's pursuant to a domestic contract, a separation agreement, or a court order. So really, when you're looking at it, child protection matters and adoptions always go to the Ontario Court of Justice. Divorce and property always go to the Superior Court of Justice. A lot of other issues, and I think we're going to be going into a little bit more detail about that later, such as like child support, spousal support, parenting time, decision making for kids, all that kind of stuff could be done in either court. Property matters always go to the Superior Court. Adoptions and child protection always go to the Ontario Court of Justice. And as I said, if you're in a unified family court jurisdiction, you don't have to worry about that. It's one-stop shopping, so you don't have to pick and choose. So if you're not sure because of where you live, which court you should go, you can contact your local family court office. And in some jurisdictions, the Ontario Court of Justice and the Superior Court of Justice are both located in the same building. For example, this is the situation in Guelph. In other locations, you might actually have the Ontario Court of Justice in a completely separate building from the Superior Court of Justice. And again, that's like what happens in Toronto. So you really have to figure out which court you should be going to, and it can be dependent on what your issues are and what you're actually asking the court to do for you. Now, one of the questions that quite often comes up is about court filing fees. So if you're looking at whether you've got to pay fees to go to court for a family law case in Ontario, if you're going to the Ontario Court of Justice, there are no fees. So if you start an application or you're responding to an application in a family law matter in Ontario, there are no fees for filing documents at the Ontario Court of Justice. If you're going to the Superior Court of Justice or the Unified Family Court, there may actually be fees that are involved. If you're starting a new case at the Superior Court of Justice level, there may be a fee of $202 to start an application. If you're responding to the application, if there's no divorce involved, there may be a fee of $161 that needs to be paid. If it's divorce, it could be $202. And then if you are actually going to set a matter down for trial, there's an additional filing fee when you're in the Superior Court of $420. But even if you're in the Superior Court and if a filing fee is applicable to your case, and again, the family court office staff will be able to tell you whether your matter is one that will draw a fee or not. There's also an option that if you can't afford to pay a filing fee, you can apply to have your fees waived. And there's a fee waiver request form that you can do. And so the court will take a look at your financial situation to decide whether you're eligible for the waiver or not. If you are eligible, most fees will not be applied to your case. And then you will be given a certificate that you have to show to the court staff when you file a document with the court so that they know that you're exempt. But it is something that you can do. If you are in the Superior Court and your matter does draw fees, you can apply for the waiver for that. So once you've figured out what level of court you've got to go in, then it's a question of, okay, now that I know what level I got to go to, where actually do I go to court? And there are rules about where you can start your court case. Like, never mind what level of court, it's actually geographically where can you start your case. And usually when you're dealing with family law issues, you have to start your case in the municipality where either you or your spouse lives, if there are no issues about parenting time or decision-making responsibility with respect to kids, or if there are children and the issues that you need to go to court for involve the children, you have to bring the matter to the court in which the children reside. So for example, if you're married and you're looking for a divorce and the only issue is going to be spousal support, there are no kids, then you can bring it either where you live or where your spouse lives. If there are children involved and the children are living with your spouse and you're not living in the same city, then you would have to start the proceedings in the city where the children actually reside. So the kids are the ones that decide where your case is going to go if they're an issue. Otherwise, it's where either you or your spouse live. So, and again, if you really want to get technical about it, it's actually set out in Rule 5 of the family law rules. It'll tell you where you can start your family law case. So that pretty well explains the different levels of court you can choose and where you actually have to start your case, depending on where you live and what your issues are.